Hi friends, in this video we are going to deal with the important judgment titled Prem Shankar Prasad versus the State of Bihar and another, pronounced on 21st October 2021. This judgment deals with that an absconder and proclaimed offender is not entitled to relief of anticipatory bail. To know more about this case synopsis, please watch the video fully. The facts of the case would be that FIR filed by appellant against accused for the offences punishable under sections 406, 407, 468, 506 of the Indian Penal Code. A warrant of arrest issued by the Chief Judicial Magistrate. Thereafter, accused is absconding and concealing himself to avoid service of warrant of arrest. Then Chief Judicial Magistrate issue a proclamation against accused under section 82 of the CRPC. Only thereafter, an issuance of proclamation under section 82 of the CRPC, accused filed anticipatory bail application before trial court. The trial court dismissed the anticipatory bail application on the ground that as the accused is absconding and even the proceedings under section 82/83 of CRPC have been issued, the accused is not entitled to the anticipatory bail. Thereafter, the accused approached the High Court, which granted the anticipatory bail. The counsel for the appellant submitted that the High Court has committed a grave error in allowing the anticipatory bail application. The counsel for the accused argued that merely because the check was given and the same came to be dishonored, it cannot be said that the offences under sections 406 and 420 of IPC is made out. At the most, the case may fall under section 138 of Negotiable Instruments Act 1881. The Supreme Court has held that there is a prima facie case against the accused. It has come on record that the arrest warrant was issued by the magistrate and thereafter proceedings under sections 82/83 of CRPC have been initiated pursuant to the order passed by the Chief Judicial Magistrate. Despite the fact that it was brought to the notice of the High Court that accused is absconding and even the proceedings under sections 82/83 of CRPC have been initiated, the High Court has just ignored the aforesaid relevant aspects and granted anticipatory bail to the accused by observing that the nature of accusation is arising out of a business transaction. The specific allegations of cheating etc. which came to be considered by additional sessions judge has not at all been considered by the High Court. Even the High Court has just ignored the factum of initiation of proceedings under sections 82/83 of CRPC. The aforesaid relevant aspect on grant of anticipatory bail are not to have been ignored by the High Court and are to have been considered by it very seriously and not casually. In the case of State of Madhya Pradesh versus Pradeep Sharma, it was held that if anyone is declared as an absconder and proclaimed offender in terms of section 82 of CRPC, he is not entitled to relief of anticipatory bail. Thus, the High Court has committed a grave error in granting anticipatory bail to accused, ignoring the proceedings under section 82/83 of CRPC. Even in the case of a business transaction also, there may be offences under IPC, more particularly sections 406, 420, 467, 468, etc. What is required to be considered is the nature of allegation and the accusation, and not that the nature of accusation is arising out of a business transaction. At this stage, it is required to be noted that accused has been charge sheeted for the offences punishable under sections 406 and 420 etc. and a charge sheet has been filed in magistrate court. In view of the above and for the reasons stated above, the impugned judgment and order passed by the High Court granting anticipatory bail to accused is unsustainable and deserves to be quashed and set aside, and is accordingly quashed and set aside. Friends, to conclude, in this video we have seen that an absconder and proclaimed offender is not entitled to relief of anticipatory bail as per Prem Shankar Prasad versus State of Bihar and another case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.